Hi, everyone. Thank you so much for joining us tonight. I'm on here. My name is Kat Kanani, and I am the facilitator for the Autism Support Group, along with my co-facilitator, Hadil Amari. And our guest tonight is Anne Roboloff, and I will do a quick bio of her, and then she will jump into her presentation tonight. And Anne Marshall Roboloff has been working in the field of estate planning, conservatorship, and elder law since the mid-90s, and earned her BS in political science and psychology from Santa Clara University, and her JD and Master of Social Work from Tulane University, and is a frequent speaker at Bay Area events and recently coordinated with a number of local financial planners to provide education on ways they can aid their clients to avoid court involvement and plan for transitions within families. Working with her clients, Anne plans for their immediate and long-term security. With an educational approach, she uses her legal and cooperative family skills to facilitate informed decision-making. She supports families with estate planning, incapacity, special needs, and elder care, and is an active member of the State Bar of California and the Silicon Valley Bar Association. She supports Hope Services and the Alzheimer's Association. Anne and her family live in Soquel, where they enjoy hiking and gardening. Thank you, Anne, for being here tonight. It's all yours.
You're welcome. Okay, so we are going to talk about limited conservatorship. So before I get started, I want to just talk a little bit about conservatorship as a concept. It is the legal mechanism by which a court can restrict the legal rights of the conservatee. So the courts take that very seriously. Limited conservatorships are kind of they're something that the court system, the judges, the practitioners of conservatorship in general really enjoy working on limited conservatorships. The other types of conservatorships tend to be a little bit different in nature. So a general probate conservatorship is something that usually is related to a dementia diagnosis or a head injury. LPS conservatorship is the other type of conservatorship. It is very different. It's for mental health and for only those so severely suffering from their mental illness that they are a danger to themselves or others. And so those are for the types of conservatorship that would be created for somebody who has had an interaction with the police or has been taken into custody because they're so unsafe that they can't be out in public without being in a locked facility. So those types of conservatorship are not what we're going to be talking about tonight. So limited conservatorships are kind of lovely in comparison because although we are taking legally, the process is to restrict a disabled individual's legal rights. It's often put in place in a way that is very supportive and allows parents to continue parenting their children as they move past the age of 18. So to qualify for a limited conservatorship, distinct and apart from the other types of conservatorship that I just mentioned, a child needs to be diagnosed with a disability before the age of 18. And because it requires regional center involvement, it's often very difficult to qualify for a limited conservatorship if you haven't been diagnosed with a disability during the first 3 years of life and went through the process of obtaining regional center benefits at that point. There are plenty of people who go through that process of the intake process with a regional center at a later point before the age of 18. And I've even worked some cases where we've gotten regional center benefits after the age of 18 when there was a disability onset before 18, but usually because there was a parent who wasn't very active and engaged and really proactive on behalf of their child, they weren't actually recognized as a client of the regional center and there wasn't a regional center involvement. But the longer it takes a family to access the benefits of the regional center, the harder it is to move into a limited conservatorship because of the fact that you need the regional center's involvement to obtain a limited conservatorship. So the way the regional center is involved in conservatorship is that they are required they receive a copy of the petition when the petition for conservatorship is filed with the court. And internally, they assign a psychologist, and that psychologist comes out and does an assessment. Following their assessment, they write a letter to the court. And generally, we want it to be a letter in support of conservatorship. So they usually will not do letters if the person is not already a a regional center client. Do we have any questions on this slide?
We have one question. Does a special need trust have to be in place with the conservatorship?
So no, conservatorship is not always going to be something that is alongside a special needs trust. So many conservatorships exist, and they don't have a special needs trust in the mix. Special needs trust planning is something that a limited conservatee should have considered on their behalf if there are assets to either that are already in the limited conservatee's name, or the family intends that they will be the recipient or wants to allocate funds at inheritance to that conservatee. For all other conservatees, you can have plenty of parents who don't have the means to be leaving sizable inheritances or aren't contemplating leaving an inheritance for their child, but they really truly do want to be advocating for that child once they reach the age of 18 for their medical needs, their education, their housing, and all of those things. So conservatorship is a much broader category that you would say would apply to anyone who would be able to meet these two elements of this slide here, because generally if someone's diagnosed with a disability before the age of 18 and there is regional center involvement, they're not in every case, but in many cases, there's going to be some aspect of their life that they may need assistance with, and that assistance is often received through the mechanism of a limited conservatorship. It looked like there may have been another question. Is there another question?
No, thank you.
Okay. Okay, so why conserve a special needs child? So a child turns 18 and suddenly the world determines that they're independent and able to making their own decisions. Most parents with 18-year-old children don't agree. So it's always the case that there's a little tension around the turning of 18 for every parent, I think. But certainly when there's disability, it is a much bigger deal for a number of reasons. The parent losing that authority to act as the legal parent and make decisions as the parent just because a birthday arrives can be something that feels very daunting for a family. So that is where limited conservatorship comes into play. It allows for the continued parent-child relationship. And I think that's why working on a limited conservatorship case for the judge and everyone else in the court system, including the attorney, just feels really, the court investigator, everybody, we just usually really enjoy these cases. I find the judge will be so busy on a court calendar and have so much that she needs to do that day, and she'll just ask questions and want to hear about how a child is doing. And, you know, you can just tell it like makes her day to have these limited conservatorship cases when they come before her. You're really providing a mechanism of support, and it's a really nice thing to see families come together to support each other. So often parents might both be named, whether they're still married or whether they're never married, whether they're just co-parenting. You can often see both parents named. You may have a parent or both parents and a sibling as well, aunts and uncles. So all co-conservators are jointly kind of on the hook as conservators. The conservators can't have a successor conservator named. That's something that maybe we'll see in evolution of the law. We don't have it yet, but it can be a nice way to have backup for the conservators who are going to be doing the heavy lifting, to have somebody who's already named who can jump in if there's ever a disability or a death of someone else in the family. So like in the case of parents and a sibling, that can be a nice way to create backup within a family without needing to go through the court petition process again at the time that the death or the disability occurs. Is there a question?
Yeah. So should parents of a child with severe autism establish conservatorship before the age of 18, limited versus non-conservatorship? So what do you think about that?
So if there's the qualification for, this is really important. So I'm trying not to go back on slides, but this is a really important distinction. So if you qualify for these criteria on this slide here, where a child diagnosed with disability before 18 and there is regional center involvement, certainly in the case that you're describing, that would be the case. You will need a limited conservatorship, and you should apply before the child reaches 18 so that you have a court order already in hand that is effective upon the age of 18. So immediately upon the age of 18, that order goes into effect. Generally, you need, with coronavirus, you now need more than ever before. I would have said 6 months before. Now you probably need a full year before. If you have a profound disability, you really want to be sure that you have the ability to sign off on medical procedures before the age of 18, so that as soon as that birthday rolls around, you have your order. It's already there in hand and ready to go. Things like the regional center getting their letter into the court can often be something that holds you up, where you have a court hearing assigned, you can't get your order from the judge until the regional center does their job. And so you can have things that delay your court process that have nothing to do with the application that you've put together for the court or the appropriateness of the conservatorship. There's just a lot of mechanics that need to happen. The court investigator needs to do a report. The regional center needs to do a report. The public defender is appointed to represent the child. There's a lot of mechanics that all need to come together. And so if there's a profound disability, you really need to do it ahead of time so that it's ready to go. And the term limited conservatorship would imply that it's applicable to these certain types of beneficiaries with the onset before 18. It's not really limited in any other way. So you would not want to seek a different type of conservatorship because you think you want something different because of the word limited. If you have a child with a disability before the age of 18, you do want a limited conservatorship. It is the appropriate mechanism, and in many ways, it actually is more comprehensive than any other type of conservatorship.
All right, thank you.
You're welcome. Okay, so let's see where we are. Sorry to be going back and forth here, but I just wanted to make sure we really talked about that one. It's an important question. Limited conservatorship of the person. So there are two branches of every conservatorship that need to be considered. There's the conservator of the person, and there's the conservator of the estate. So the conservator of the person has care, custody, and control. I don't love that language, but generally it's somebody who's going to be making decisions about housing. And then if there are other powers that are being requested, we can ask for those. Certainly medical is going to be conservator of the person power that we would actually ask for discreetly. Then on the estate side, we want to be able to manage the financial affairs of a developmentally disabled adult. If there is an estate that's going to be managed, the conservator of the estate has to be bonded, so has to qualify for an insurance policy to ensure their actions as the fiduciary managing money on behalf of the conservatee. And often we are going to be talking about records, and so the person powers is residence, and one of the estate powers is records. Contracts would be an estate power. Medical decision making would be a person power. Education is a person power. So these are the first five are the kind of the five standard powers that you're going to seek for all conservatorships when you're seeking limited conservatorship. Rarely granted are the kind of like social limitations on the right to marry, social and sexual contact. So often those are not granted unless you've had an issue where you had somebody who has acted to get out against another person or has been the victim. And then in those cases, you may have certain other powers that are granted, but the first five, residence, records, contract, medical, and education, are generally the powers that you are seeking as a limited conservator. So I see we have a question.
Yeah, so can parents be held financially responsible for behavior liability issues of a conserved individual?
No, well, so you have the responsibility to act, to do everything that you can to make good decisions for the conservatee. You aren't liable for their decisions. So a conservator will advocate in the court system for criminal charges that are brought against a disabled person. Having conservatorship can be helpful, but there are lots of problems with the criminal justice system and just a lack of understanding of disabilities. So playing the advocate, the role of advocate is very important. And yes, a requirement of being a conservator. A court will remove you if you don't advocate for a conservatee, but that's not the same as being held personally responsible for their actions.
Okay. Okay, and we have two questions about how to start the process. Do you start from the regional center? Is that where you start to establish the limited conservatorship?
No, so that's kind of one of the ending parts of the process, but it's required for you to finish it. So generally you would start with the court. So you have to fill out a set of paperwork that is publicly available on at least the Santa Clara County website has a self-help site that posts all the forms that you need. But generally hiring an attorney is a good idea. I have seen recently a family get through the courts pretty efficiently without an attorney, but for the most part, most of the people that I see in court that do not have an attorney have a very difficult time and end up spending a lot of time missing work or not having to come back over and over and over again because they're missing some small detail here or there. As I said, there's a kind of a coordinated effort on the part of different government agencies and different people that have different roles involved in conservatorship that are all required to come together for it to move forward in the court system. So really having somebody who can guide you through that process is important. So starting with an attorney or with your own seeking of self-help through the courts, putting together a court petition and the related documents the court requires to get that through the court system is the first step. Providing all of the information about the people you want to have named as conservator. That goes to the court, it's filed, you pay a filing fee or you ask for a fee waiver. And then once you get through to having a filed petition, you're assigned a hearing date. Then you have a court investigator assigned and you hope that the regional center begins their process. And if not, you encourage them to move through their part of the process as well. And often you have an attorney assigned as well. So all those different moving parts need to kind of be coordinated to get you through the courts. But you start usually with an attorney or with the court self-help website, and you start with the court forms to submit all of the forms that are required for a limited conservatorship petition, which is a certain set of forms that have to be submitted all together to the courts. And that's the beginning of the conservatorship process. Were there other questions?
Thank you.
Okay, you're welcome. All right, I'll take any final questions before we wrap up.
Hadil, do you want to pose those last few questions?
So we have, so if you move to a new county or state, does paperwork have to be completed again?
So the change of from one county to another is pretty straightforward. It's a moving of the file from one county to another. Changing states, it varies depending on how the local states work. By and large, California is more comprehensive in the steps entailed, more expensive to navigate than any other state. So it's usually easier to export a California conservatorship to another state than it is to import one, to bring one into California. So often you're just paying to move the file, similarly to how we move between counties in California. But it would vary depending on what the state law says about them. I've moved them into other states on a number of occasions, and so far the states that I've moved them to have been easier to navigate. Generally, I would be passing it off to an attorney in that state, and that attorney would handle it going forward. We have a waiting period of 4 to 6 months right now to get a hearing date. Recently, I moved one to Texas. They had 2 weeks. They had to wait. So you're often paying less in fees. The wait time is far less. The process is less cumbersome. So it's not usually that big of a deal, but it is a process and it does need to be managed.
Okay, thank you.
You're welcome.
So I just wanted to ask this personal question for myself. I heard you say 4 to 6 months is the wait time. Did I hear that correctly?
Coronavirus has done terrible things to our courts right now. So yes, okay. That is where we are right now.
Okay.
Yeah, you can get emergency orders. So unfortunately, what that does is it means that we have more need for emergency orders because people have to wait so long to get a regular petition heard. Yeah.
Right. Okay.
The courts just went through another round of cuts. The court investigators lost 2 positions. The court staff lost 2 positions. So they each have gone from 5 to 3 people for the entire county of Santa Clara, for example. That's just Santa Clara.
Wow.
So yeah, our budget cuts have been affecting this, as well as just in general, all the coronavirus precautions have also slowed everything down. So the combination has been a little brutal on our wait times for court hearings, I will tell you.
Okay.
Unfortunately.
That is good to know.
Yeah. That's why I said and I said it was so important to spend the time on it, is that if you have a profound disability where you really might have urgent medical needs, that really it's very important they're addressed and that somebody's able to sign off on them. You really do want to get ahead of it and start like a year ahead at this point.
Okay. Okay. Hadil, did you see any last?
A question related to that. What do you need to do if your child turns 18 and you don't have one sit?
So that's, I almost wanted to say that. So thank you for asking that question. There's no too late, there's not a period where it's like too late to ask. It's just that if it's a profound disability, it's more likely to turn into an emergency if you wait. So I would say that's why you should, be planning proactively ahead of time. But generally speaking, people wait until later all the time, so there's petitions for appointment of conservator at all different ages. So there's not like a right or wrong age. It's just more a matter of having it by the time you really need it.
Okay.
All right. Thank you.
You're very welcome.
Okay. And was that the last of our conservatorship questions, Hadil?
I think we have one last question in there. How much does it cost for the conservatorship assistance?
So that's going to vary greatly between attorneys as well. Generally, I'm quoting any court action right now. I'm quoting $5,000. And if there's a complex of state issues, it would go up from there. But it's just cumbersome to get through the courts right now. So there is the self-help website. There are attorneys that do it for various fee levels.
Okay. Okay. Well. Go ahead, Hadil. Did you have anything else?
I was just going to say thank you so much. That was very, very informative.
You are very welcome.
That was wonderful. And you are just a wealth of information. Thank you for sharing with us tonight and taking all this time to cover this really important topic for us.
You're so welcome.
Okay. Thank you, everyone, for joining us. Have a great evening.
Have a great night.
Thanks.